Thank you. My name is Jeff Baker. I'm an attorney with Young, Summer, and Albany, and represent a number of the residents and property owners in the vicinity of this proposed rezoning. I've just provided you some written comments. Let me summarize some of the main points and respond to some of the statements made by Mr. Bianchini. We are strongly opposed to this rezoning. This rezoning, if it proceeds as is presently presented, is patently illegal. It is striking upon our review of the record, and I appreciate the assistance of the town in making the file available. There's absolutely no supporting information available in the file to support the determination or the basis of the request. A year ago, in 2009, the town board amended the zoning plan, the comprehensive plan, by incorporating the Exit 25 study and a variety of others, including the map. It specifically redesignated this area as professional office residential. It is not P2, it is not light industrial as under the previous comprehensive plan. That plan was a product of extensive studies, committee meetings, and years of work by this town, which led to the conclusion that these properties in particular, on the south side of Route 7, will be professional office residential for the purpose of providing a buffer from Route 7 and the other activities on the north side of Route 7 to the residential properties on the south side, specifically the residential properties on the south side of Becker Drive. There is no basis at all for Mr. Bianchini to say it's compatible with the comprehensive plan or the Exit 25 study because it says the exact opposite. The fact that the town has not adopted the zoning to implement the comprehensive plan is not an excuse to ignore the comprehensive plan. You have a legal obligation to make your zoning in conformance with the comprehensive plan. I understand that this town board is a newly elected town board, and so there may be different views that you have regarding land use policies. That may be legitimate, but you cannot unilaterally change the comprehensive plan at the whim, at the request of a single developer. You have to go through the studies and do the analysis to support that work. Now, I may be mistaken, but it's my understanding in the Golub application that you heard previously, that rezoning is specifically consistent with the comprehensive plan characteristics that were developed in 2009. This is the opposite. And contrary to the Golub application, where you had a specific proposal, albeit not without the detail appropriate for a site plan review, it went through its full seeker review, and you have the full analysis associated with the application. You have no seeker information here at all. And it would be patently segmentation to allow this project to go through with absolutely no information whatsoever, because you are rezoning and making it a legal determination that the variety of uses permitted under B2, which are very extensive, is presumptively compatible with the community and with the neighborhood and will not have an adverse impact. So you are restricting, limiting the subsequent review by the planning board when you would be undertaking a site plan review. You are dividing and breaking up the project for the purposes of avoiding environmental review, and that is illegal segmentation. If the applicant is not sure exactly the type of business that they're going to be putting there, you have an obligation to do an environmental review for the full range of the permitted uses included in the B2 zone, including a full warehouse facility, a trucking terminal. None of that's been done. None of that information is there. And you certainly cannot take into any account or say that this provides a greater increase or a benefit to the tax base of the town, where you have no information of what the proposed use is going to be, what the proposed impacts are going to be, or the subsequent costs that may result of that. That is not a basis for a determination. This is the barest of bones of applications that I've ever seen, and I would guess that you've ever seen, to support the basis for such a change where you're purportedly changing both the comprehensive plan and the zoning law. And I also want to note for the record that in September of 2009, when the board was first considering this application after the public hearing, we submitted a protest petition pursuant to town law that was signed by by the owners of more than 20% of the adjoining lands. Any action to move forward with this would require a vote of 4 members of the town board to move forward. It requires a supermajority. You hear from a variety of the residents who live around there who are able to speak more particularly to the concerns that they have of this project. But it is abundantly clear. Your comprehensive plan said that this should be a professional office residential area, not a B2 area, and you are constrained to follow the dictates of that plan unless you do far more study than the non-existent study that's been undertaken so far. Thank you.